How many people were identified through that? 350,000 people were identified through that. If we are unable to read your ID, what do? We take your ID, we enter the number of your ID, and then your details, your 10 fingerprints, together with your ID come up. When that comes up, what do? We tell you to put your fingers, any of your fingers. 10 fingers, you put it, and you identify. In fact, the identification of the 1.6 million people was more robust than anything, because you undergo through two systems. One, which is your alphanumeric identification, as well as biometric. It is only 300,000 people who are identified through what we call supervisor's override. A presiding officer has an override when you cannot be identified in any of these methods. But 96% of the Kenyans who went to the polling stations on that day were identified through the KIMS kit. The transaction logs are available. You can trace back to the transaction logs. Everything is available, my lord. And that is why we provided to the court to satisfy that actually we can prove what the chairman did on that day, and the verification that the chairman undertook was robust.
So in other words, even that one, even that information is in the
information is there, but importantly, that information is also in the affidavit of Silas Jero, which was filed on the 12th. It enumerates what processes we underwent, and that information is also there. In fact, we have given you what we call KIMS transaction log. If you did a small arithmetic of the KIMS transaction log of the people who are identified by the biometric, the people who are identified by documentary and biometric, and the people who are identified alphanumeric and biometric, you will not come to any other conclusion, but to the conclusion that 96% of the Kenyans who went through the polling station were identified through that process. My lord, unless you have any other question for me, we think this is a misconceived application and it should be dismissed with costs.
Thank you. Thank you very much, Mr. Muhati.
Thank you.
His name is Mahat, not Muhati, my lord.
I'm corrected.
Thank you.
Thank you.
My lord, I can see my colleague is on his feet, but the directions given was that the application was only limited to the two of us, IBC and ourselves, unless it's acting for IBC.
What's wrong with it?
There is no... Mr. Abnasir, you are appearing for the third respondent.
Yes, my lord, third respondent.
Yes, that would be the party who would be adversely affected.
Very well.
Yes.
Most adversely, my lord, if I may add. Yes, my lord, in opposing this application, we'll be doing under 4 headings. One is that the entire application before the court is not pleaded in the petition. It's not pleaded in the petition. Secondly, my lord, the right to information under Article 35 of the Constitution cannot be litigated in the Supreme Court during a petition under 140. The right to information under Article 35 cannot be litigated in a petition under 140. My lord, thirdly, we will be arguing and hope to persuade you that your decision of 28 August on scrutiny and verification was a decision made per incuriam, and this court should depart from that. Lastly, my lord, and this will be argued by my learned friend, Mr. Masharia, the applications or the prayers the petitioner is seeking are either impossible or impracticable or unnecessary. And my lord, as my learned friend, Mr. Mahat for IBC rightly argued, and I will come to that when I'm arguing the second point, there is the proper procedure for obtaining information under Article 35 is outside this court. It's not inside this court. But my Lord, let me start with the first one. Are these prayers pleaded, my Lord? Are they pleaded in the petition? And my Lord...
Sorry, Mr. Abnazir, who else did you say is...
Yes, my learned friend, Masharia.
Is with you in...
I will give him part of my time.
Okay, okay.
Yes.
That's what I want to be sure. That you are sharing the 30 minutes.
Yes, my Lord, we will share 30 minutes, yes. So, my Lord, it's my submission that the prayers and all the issues raised in this petition are not pleaded, in the application are not pleaded in the petition. And my Lord, my learned friend, when she is replying, will show you, for example, in paragraph 6, when she talks of Muranga, and she lists 10 polling stations. Let her show you where those 10 polling stations are in the petition. When she talks of Garissa, my Lord, in 6B, and she lists about 17 polling stations, let her show you where those polling stations are pleaded. My Lord, in prayer 8, for example, when she talks of all those constituencies in prayer 8, they are not pleaded, my Lord. And we could not, when we didn't have an answer or an opportunity to answer those when we are replying to this petition. Similarly, my Lord, paragraph 9, completely not pleaded. Paragraph 10, not pleaded. Paragraph 12, not pleaded. Paragraph 15, not pleaded. Paragraph 18, not pleaded, my Lord. So, my Lord, the mischief is very clear, my Lord, because a petition under 140 has certain time limits. The petitioner files the petition in a skeleton form, then brings an application like this to expand the perimeters of that petition. It's a complete abuse of process, my Lord. And my Lord, we have seen too many instances where a petition that is dead on filing is suddenly kickstarted or gets a new lease of life through an application for the right to information, my Lord. I think the example is fairly obvious. So, my Lord, there are a lot of authorities, my Lord, but I don't want to take your time on this. There is a supplement, there is a list of authorities, my Lord, 6 authorities from the High Court and the Court of Appeal, which states that a party who does not plead a certain facts or law cannot raise that in a subsequent application or during the trial of the same. My Lord, let me go to the second one, or the second ground, my Lord. Before I go that, my Lord, the bar you set, my Lord, in the 1st September decision is fairly low, my Lord. When a party makes this application and the court grants those prayers, if the first and second respondents don't obey those orders or don't comply, the test you have set now is that you will make an adverse inference, my Lord, and you will nullify the presidential election. So, my Lord, because of that, the court has to relook into that, and I think we will talk it at another time, that those issues must be pleaded so that all the parties know that this is the case they face during the trial. It should not come midstream during the trial. My Lord, the second point is that can this court, my Lord, in a petition under 140, do what is the exclusive preserve of the High Court, my Lord? And my Lord, I think my Lord Justice Leonora will tell you, because he has been sitting as the inaugural judge of the Constitutional Court, that Article 23 of the Constitution gives the High Court exclusive monopoly for any litigation under the Bill of Rights. No other court, my Lord. The Court of Appeal can do or can hear it if there is an appeal from the High Court, and this court, my Lord, and my ladies, can do it if there is an appeal. But, my Lord, can this court, in an application like the one filed by the petitioner, make a litigation on a Bill of Rights, my Lord? No, it can't, my Lord. Let me read for you, my Lord, what Article 23(1) says. It says the High Court has jurisdiction in accordance with Article 165 to hear and determine application for redress of denial, violation or infringement of, or a threat to a right or a fundamental right. So, my Lord, the petition is now saying that they want to access certain information. They want to exercise their right to information. Under Article 23(1), it's only the High Court that can address that right when a person is denied and when a person is allowed. My Lord, if you look at your decision on 28 August on this similar application, you will find that, my Lord, you could not base that decision on a specific provision of the Constitution or a specific provision of the statute that allows this court to hear a Bill of Rights in the first instance. You are on more firm and solid ground when you are analyzing the law as it relates to scrutiny. Because, my Lord, both the Election Act and the rules therein provide specifically for an election court to order a scrutiny, and an election court, my Lord, include the Supreme Court. But, my Lord, when you retire and you look at that ruling of 28, you will not find any provision in the law that allows this court to hear that matter in the first instance, my Lord. And, my Lord, I don't want to emphasize or even say it, but there are so many decisions of this court where this court has warned itself of the danger of encroaching into the jurisdiction of both the High Court and the Court of Appeal. And the other courts, my Lord, respectfully have avoided to encroach into your jurisdiction. So, my Lord, the point we're making here is that
if they did that, they will face the wrath.
My Lord, they are conscious of that. And that's why they have kept very far from your exclusive jurisdiction. But, my Lord, both under 140 and Article 163 of the Constitution, my Lord, you will not find powers donated to this court to hear an application that seeks the validation of a right under the Bill of Rights, my Lord. But, my Lord, there is one case I will just refer to you. It's a High Court decision. My Lord, it's case number 4. If you look at the third respondent's list of authority, the case number 4 is Nelson Harvey and others versus the Inspector General of Police and 5 others. My Lord, this case is a case where the petitioners filed a constitutional petition seeking to stop the DPP from prosecuting them in that suit. Yes, yes. So, my Lord, in midstream, they brought an application under Article 35 of the Constitution in which they sought certain information on how the DPP reached certain decisions. And an objection was raised that in that petition that seeks to stop prosecution, you cannot open midstream another application or another right under the Bill of Rights, i.e. 35, and seek certain orders. We argued, my Lord, of course it's not binding, but you will find very persuasive law that you cannot, in a suit you have filed, bring a fresh suit, even in the High Court. And, my Lord, when you retire, I will pray that you look into that. But, my Lord, this court has... My Lord, this court has said on so many occasions, including Peter Munya case, including Nadif Jama, and many other cases, that the function of scrutiny is not to provide evidence, new evidence, or it's not a fishing expedition. But, my Lord, in the Supreme Court now, it is common that when a party does not have enough evidence to win the case, he will file an application under Article 35 of the Constitution, and suddenly the petition assumes a totally different character. And that's why I was submitting, my Lord, that if you look at your decision of 1st September, the entire petition, 99% of that petition, the 4-judge majority decision, was based on the finding during the ruling of the finding pursuant to the ruling of 28, my Lord. 98%, my Lord. In fact, my Lord, that was a case that was entirely determined on the interlocutory application because it becomes so vital. And when we argued the petition subsequently, I mean, it was only the interpretation of Section 83 of the Evidence Act that was new to the petition. So, my Lord, it's so important that a party who comes to this court when they file their petition should prove their case according to the four corners of that petition. The moment we open, we will have a court process driven. The court will take over. My Lord, the court take over. The court actually refurbishes and renovates the petitioner's case and gives it more zest and life. And I think that's detrimental to the respondents. Actually, my Lord, a successful application under Article 35 is a transplant of the petition. It gives it more energy, it gives it more organs. But my Lord, my submission is that the petitioner should prove the case as they filed. My Lord, for those reasons, it's my humble submission that your ruling of 28 August 2017 is, insofar as it relates to Article 35, was a decision issued per inquirium. And my Lord, there is no harm in this court departing from the same. I pray and encourage and submit, my Lord, that you so depart, because respectfully, my Lord, I think that was bad law. The first part of it was good law when it comes to scrutiny, and it was a very good decision, my Lord. But, my Lord, you will find that the later part, it hangs. It has no foundation, my Lord. My Lord, with that, I will invite my learned friend to show how the orders, despite my, in addition to my submission, actually, it's impossible, it's impracticable, and as shown by Mahad, very unnecessary. My Lords, unless you have any information, that's my part of the submission. My Lord, just one point. I'm sorry. I'm sorry, my Lord. My apologies. My Lord, just before I finish, I will just draw your attention to Raila 2013. Paragraphs 204, my Lord, to 209. Very, very lucid pronunciation, very lucid, my Lord, exposition on the powers of this court as an election court, my Lord. The powers, the jurisdiction, the limit, my Lord. My Lord, just look at what you said in 206 and 207. And my Lord, when the court retires and you look at 206 and 207, you will agree with my submission as your powers to adjudicate of appeal of rights. I'm most obliged.
If it pleases my lords,
Yes, sir.
my lord the Chief Justice and the judges of the Supreme Court, I will split my presentation in 9 points that deal with the prejudice to be occasioned by the order sought to the third respondent. I begin, my lords, with the characterization of the application made before you. What is before you is, in truth, not a scrutiny application, but in fact an application for an audit. And there is a significant distinction to be drawn between an audit and a scrutiny. I rely not on my own authority, but on the authority of this court and our own courts here. My Lord, the judiciary prepared a very helpful bench book on electoral dispute resolution, and I refer you to page 78 of that document, which is available to all of us. I got a copy from the judiciary website. And in particular, paragraphs 4.6.5.1. The point it makes, my Lord, is this, is that a scrutiny inevitably entails the conduct of a recount. I have read that statement verbatim from that particular document, but that the converse is not always true. Now, as we've seen this morning, we run then into the danger of converting the scrutiny into a trial within a trial. We start examining evidence peremptorily at the beginning. My learned friend, Mr. Mahat, has done a fantastic job explaining what they have provided. My lords, what we did when we received the affidavit of Mr. Silas Njero is quickly do an audit of what had been provided. And what we've done at page 68 of our affidavit, which we have provided to you, we have prepared a table documenting everything that we got there. And one of the dangers of this, and this is one of the prejudicial issues we are to raise here, is the danger of information or data overload. The information given is not in fact 40 gigabytes, it's actually 48 gigabytes from my examination yesterday. Now, I read history to do my law, and so I've had to do some tuition yesterday to understand exactly what that means. But beginning at page 68, we do a checklist of everything that we have been given, some of which was already available. You will find, for example, in the affidavit of Mr. David Chirchir, in response to the affidavit of Mr. Njonjo Moe, a 600-page document of the logs obtained from the KIMS kit. This is available on the website for IBC, free of charge to every Kenyan and indeed to the entire world for examination. Now, you will then find 13 items we have listed in that particular document. And at the bottom of that list, and you will find that at page 70, we have done a quick analysis from our experts what that information means. Now, apparently 48 gigabytes, and I can cut down quickly to the chase. When broken down into megabytes, that is 48,000 megabytes, and I am told that 2 kilobytes, has about 500 pages of information. The 48 gigabytes supplied to all of us is 24 million documents. That is the information that has been provided in that particular document. Even if we were to assign a 100-man team to look through this at the supersonic speed of a second per document, we'd be here at least for 3 years looking at that document. We'd be here looking at that information. And so that is not an idle complaint, my lord, because you dealt with it in the case of Nadhif Jama Adam versus Abdikarim Osman Mohammed. My lords, we have filed before you a decision you will find at page 5 of our bundle of authorities, where you addressed the question at paragraph 80 of the consequences of inability to deal with material and time. Overloading parties with 24 million pages of documents is an Article 50 infringement. We cannot, within 14 days, look through 24 million pages and come up with anything resembling a judicious finding. It is impossible, my lords. But again, my lords, our memories are fresh. At paragraph 403 of your majority decision, you, I think, directed the problem to where it should be, which is Parliament. And I think you said that Parliament has been asked time and time again, please expand the time for us to do this. But you said that in the meantime, we do not have sufficient time to do things like a scrutiny. And so, my lord, that, and I did a count again yesterday, the information availed during the 8th August election petition was 8 gigabytes. What we've been given now is 6 times what we were given. And on that occasion, at least on the Form 34As, the scrutiny only managed to go through 4,000 forms or so. We now have 8 times that to look through. The third item under the Article 50 prejudice issue we raise is the one my learned senior has discussed, and again you'll find that properly articulated in the Nadhif Jama case, is that we do not know what case we are to meet and respond to. And a fourth issue, I think, which arises from that, my lords, is Article 140, Sub-Article 3, and I think my learned senior, Mr. Ngati, has made that point while he was here before, makes it very clear what you're to file and within what time. The introduction of all these new documents at this late stage has the functional effect of reopening the petition out of time and in violation of Article 140, Sub-Article 3. I then now move to certain areas that perhaps were not covered by my friends here before. One of the areas that has been attacked by the petitioners before you is the question of the voters' register. Now, the voters register in electronic form has been available on the IEBC website since at least the 9th of June 2017. The KPMG audit, that was a statutory mechanism, I believe under the provisions of Article 7, 8, or 9, or 10 of the Elections Act, was released on the 9th of June 2017. Attached to that, and my learned friends from the petitioners have skipped that from their presentation, was a list of dead voters and those who had shared IDs. My lords, I have taken the time to produce that for you at pages 12 to 20 of our replying affidavit. There's a list of those which was part of that report. Now, what then happened, my lords, is that the IEBC then opened up the register for verification on the 10th of May 2017 by way of a gazette notice. You will find that gazette notice at page 21. The purpose of that opening of the register was so that the complaints they bring here today could be examined and brought before a court well before the election dates. On the 27th of June 2017, the IEBC closed the register as required by law, and you will find the gazette notice for that at pages 22 to 48. They then closed it again after the elections. I believe they closed on the 5th of September 2017, pursuant to the provisions of Section 5, subsection 1. You will find a gazette notice at pages 49 to 50. The point of all this, my lord, being this: they have had since at least June to come and challenge any aspect of the voters' register they wished to do. They come on the eve of the hearing of a time-constrained 4 or 3 petitions and say they want that opened up all over again. And this is not the register that was merely used for the fresh presidential election. This is also the register that was used for the general election itself. I go to the next point. The application is in fact designed to circumvent statutory limitations set out at Section 6 of the Access to Information Act. Section 6 of the Access to Information Act sets out limitations to information that cannot be given or that is not available to be given under that statute. It is also an attempt to circumvent Section 27 of the IEBC Act, again, which sets out limitations as to what information can and cannot be given out and within what time period. In other words, my lords, Article 35 is not an unlimited statute granting rights to information. Indeed, the purpose of these statutes, and including Article 35, is to grant information where that information has been refused. But as demonstrated here by my colleagues before me, that information has been readily available and has been granted to all these parties. Now, the party before you, and this is another point now, has a special place. In the affidavit of Mr. Njonjo Moe, I believe it's the first 6 or so paragraphs, he states that he is doing this as part of a group of civil society organizations called Kura Yangu Sauti Yangu. And he then says that they are indeed accredited observers under the provisions of Section 42 and Regulation 94 of the General Regulations. Now, when the IEBC provided this information, the notice was very clear. They said, this information is available to observers, candidates, and their agents from as early as the date the results were announced. And so they've had 10 days to have obtained all this information as a matter of right and public notice and record. They cannot come at this late stage and tell us they want to burden us with all these millions of documents, having filed their petition. And indeed, it's instructive that we began our session this morning with the same petitioner coming to say they did not have enough time to even file the little they have. They did not have enough time. They now want more time to file another 24 million pages, which cannot be examined at this late stage. There is an issue that has been raised here as regards, and I think maybe before I go to that issue, perhaps I should say, coming and closing in a circumvention of the statutory provisions. The framework for managing our elections has certain sections embedded in it for the provision of information. For example, Section 39(1)(c), subsection C, has a requirement that forms are to be uploaded on a portal. It is a statutory requirement. As of the date of filing this application, and indeed in a day or so of the time the results were being announced, I checked. There are 37,187 Form A's uploaded, available free of charge to Kenyans and indeed the entire world. There is 266 Form 34B's available pursuant to that statutory provision, and there is a 364-page Form 34C again, also on that website, available for verification and inspection. And so the mechanisms provided by law, and my lord, I think the point has also been made here, that Section 12, subsection 2 of the Elections Act makes provision for certified copies of Form 34A, B, and C to be delivered to this court. Now, this was a provision that was amended. It was a provision that was brought in together with 39(1)(c), subsection C, during what came to be known as the Kiraito-Orengo Joint Committee report. And those forms are here. The danger and the prejudice we run, the risk we run here, is having so many forms that we start making mistakes because of data overload. We cannot tell which are the proper forms here. We cannot tell which ones came at what point because we have 24 million pages. It's not humanly possible to look at all those, at all that material. Now, some of the other prejudice we've raised in our replying affidavit, my lord, is an issue raised by Section 27 of the IBC Act, and it's an issue to do with confidentiality of information.
Mr. Macharia, you have less than...
1 second, my lord, or 1 minute, I think. Yes. 1.5 minutes, my lord, yes. I will try and fit in everything I have to say in that point, my lord. The point is this. Section 27, and my lords will have a look at this, has provisions regarding the confidential treatment of information. Among the things you will see we have attached before you here are 2 letters which you will find at pages 51 and page 60, dealing with what happened when this honorable court, as it was entitled to do, granted an order for access to IT systems at the IBC. The next set of things that happened, of course, was that the deponent of the affidavit himself, Mr. Davis Churchill, found himself the branch of attacks on the basis of what was or was not in those servers. This was information that had been provided pursuant to the court order and information that had been provided by the IBC itself as part of the transparency requirements. Those complaints are now the subject of criminal investigations. And so, my lords, some of the information sought here, without proper mechanisms and without proper safeguards as to the confidentiality of that information or as to how it will be used, then leads to prejudicial results. My lords, permit me to state a few things from what my learned friend, Ms. Julie, said. She said they want the full picture and that quick results came after 15 minutes, and that's one of the grounds. The problem with the 8th August election was that the results came too slowly.
Mr. Macharia,
yes.
Your time has run out.
Thank you, my lord.
So find a way of winding up in a minute?
Yes.
Yes.
I think, my lords, maybe let's me end with a figure, because this is what we are here about. You've been told there are 19 polling stations that that they've identified for purposes of this scrutiny. Again, to give a figure. Those represent, and those are the only ones they've mentioned in their pleadings, 0.05% of the polling stations where an election was conducted. That cannot be a basis, my lord, even from a numerical perspective. If this were a medical test, it would come out negative, for scrutiny positive, my lord. Thank you very much, my lord, for listening to me and for granting me a bit of extra time to say what I need to say. Thank you.
Thank you. Thank you very much, Mr. Macharia.
My lord, although you had ruled earlier that no parties will be heard, we wish to clarify something for 5 minutes, not more than 5 minutes.
No.
On that issue, my lord.
For who are you appearing?
For the 4th respondent.
For?
The 4th respondent.
No. We said
Yes, my lord, you had made that ruling earlier, and it was restricted to the two parties, but you did allow one of the parties 30 minutes. We are asking for 5. We do not need more than 5 minutes.
Yes, Mr. Mwangi, 5 minutes only.
My learned friend, Mr. Awele, will take the point.
My Lord, I'd like to address you on only one point that I had being raised by my learned friend, Mr. Mahat. My Lord, you asked a very pertinent question. What does it mean to the voter turnout of 96% when it is said that 1.6 million voters were not identified biometrically? The answer Mr. Mahat gave to you, my Lord, was that that was based on a misapprehension of what the complementary mechanism is. My Lord, in the run-up to the 8th of August elections, the fourth respondent engaged in a number of litigation matters at the High Court to clarify a number of issues for the election. One of those issues was what exactly is the complementary mechanism that is contemplated under Section 44A of the Elections Act. We litigated at the High Court and eventually ended up at the Court of Appeal, my Lord, in Civil Appeal number 258 of 2017. Except, my Lord, for the petitioners, all the parties in petition number 4 were parties to that action, to that appeal, save for the third respondent in this petition number 4, who was represented by the Jubilee Party. My Lord, in the course of that appeal, an internal memo surfaced. The memo, my Lord, was dated the 27th of July, 2017, by the IEBC. That memo, my Lord, is signed by the CEO of the IEBC, Ezra Chiloba, and it basically set out what a complementary mechanism under Section 44A is. My Lords would want to know that the parties then went on to record a consent, which the IEBC was a party to, agreeing that that internal memo, the complementary mechanism, is what is defined in that memo. And this is what it is, my Lord. It is where a voter cannot be identified using biometrics, then the presiding officer shall use a complementary mechanism of alphanumeric search in the presence of agents, and the voter shall fill Form 32A before being issued with 6 ballot papers. That is a complementary mechanism, where a voter cannot be identified using biometrics. So the contention by my learned friend that the misapprehension was based on the manner in which the voters were identified, in the sense that those who were identified alphanumerically were in fact also identified biometrically, cannot lie. It is inconsistent, unless, of course, the IEBC is now saying that after the 8th of August elections, a new complementary mechanism was established. And this is the very reason why we went to the High Court, to establish what exactly this complementary mechanism is.
With all due respect, my lords, humbly, he's opening up areas where you cannot respond. Yes.
So, my Lord, all I'm saying is that
it is very pertinently unfair.
My Lord, this is a decision. I've cited the civil appeal number, and I'm only making this known to the court so that as you retire to write your decision, my Lord, you need to be mindful that the Court of Appeal has made a decision which has not been appealed from, my Lord, on what the complementary mechanism is. That is all I wish to state. Thank you, my lord.
Yeah, Mr. Mahat, I'll give you a minute. You are saying, come up front. I asked you specifically about 1.6 million voters said not to have been identified by the KIMS kit.
Yes.
And he's disputing, he's saying you are following some other mechanism which is not allowed by law. Can you clarify that?
My lord, that is not the position.
Is the microphone on?
Yes, I think it is on. My lord, to the question, so the 44A says that any person who is not identified by biometrically, then you go to a complementary mechanism.
Yes.
The complementary mechanism that you are talking of, when someone talks of alphanumeric search, the court should be mindful, what does it mean? Alphanumeric search, and I have explained to you, there are 3 modes within which the KIMS kit identifies a person. The first mode is through the biometric, through the fingerprint. And I've said 5.5 million Kenyans were identified through the fingerprint on the 26th of August, the thumbprint. For the persons whose thumbprint cannot be read, what we do is we take the ID cards and we have an MRZ scanner. And that ID is scanned, his details pop up. What we tell is localization, because you are looking through 7,000 fingerprints in one kit, 700 people times 10 fingerprints. And even when you go to hospital, sometimes, my lords, you will get a false acceptance rate. You are told you have a disease which you don't have when this test is, so they are false negative. So, but when we localize for 10 fingerprints, we lower the false rejection rate, the rate which someone can be told that he's not in the KIM, but he actually is. So, when we do the documentary search with the MRZ scanner, the ID of the person does not come in. Now, the third aspect is what happens when, for senior citizens, or persons who have not kept their ID and passports very well. We take the ID details, we'll take their names and the ID number. What happens is the KIMS kit now will produce their details, both the 10 fingerprints as well as the ID details, the biographic data. After that, we tell them, because maybe their thumbprint, because we start with the thumbprint, does not have all the details, we tell them to put any of the other fingers, some of them the 10, others the 9. Then we identify them. So the idea that through alphanumeric search, it means that some person has not been identified biometrically is not true. In fact, you are identified through your ID details, and secondly, you are identified through biometric. The complementary mechanism that it has in mind, because all those people are identified through the KIMS kit, and they are identified biometrically. The complementary mechanism that we don't have is what happens to the person who cannot, even after the alphanumeric search, his details do not come in. Okay. Then the manual complementary mechanism kicks in, which is we have the physical register. There's a process for even that. We have a physical register. We look through the register. It has their biographic data, the ID and everything, and we look through it and we cancel out. We put that register after the end of the polling station into the ballot boxes, where 32A has also been generated, which is put there. So the idea is you have to understand the KIMS kit for you to actually make some of those submissions that they are making. And every person has been identified through that process. So
the alpha, what do you call it?
The alphanumeric search.
Yes, it's part of the identification.
It ends up with a biometric identification.
Okay. All right. Yes, Soweto. You heard where you are supposed to go fishing.
My Lord, let me start first by dealing with the question of where we're supposed to go fishing.
Yes.
I think my colleagues are taking advantage of my being a lady. Just a minute, just a minute. My Lord,
ladies don't fish.
My Lords, the first and second respondents served us with their response at 1 a.m. yesterday. We waited for them. One of the things they say they served us with is this hard disk. It was not served on us. It was not given to us. As it is, by the time they showed up at 1 a.m., they were way out of time. We were courteous to them, we waited for them, we received their documents. The hard disk was not one of those documents. Later on in the day, at about 12:38 p.m., somebody from the IBC brought the hard disk to us and said it had fallen out accidentally. By the time we had already filed our application. So if it is to look for these documents, or we being accused of not having read what they had given us, it is not true, because we did not have it. That was just to set the record straight. My Lord, we have been accused of not reading.
Before you go there, now that you have that key, hard disk, do you want us to give you time to peruse through it and see whether the information you seek is there, so that we don't even have to rule over this on this application?
My Lord, I think that might not be necessary, because what we want is live access, not pre-downloaded data whose origin is not verifiable. And I say this with the caution that the last time in the August petition, this was one of the issues that came up, because the second respondent, first and second respondent, did not want to give live access to their documents or to their servers. They wanted to give pre-downloaded forms or pre-downloaded data that could not be verified, could not be ascertained. So it is not helpful that they claim they have given us this data that has already been pre-downloaded. It also goes to deal with the issue that there are several different types of forms out there. That, of course, raises then the question as to why do we have different returns. My clients, who were observers in the field, obtained forms. Those forms are different from what the first and second respondent uploaded onto their portal. The question is, why are they different? The purpose of scrutiny is then to verify the information or the data, because these forms were availed by the first and the second respondents. If they do not correspond with what is in the KIMS data, which should have captured the details, then this court must determine. Again, we talk about forgery fraud, which was an issue that arose out of the last election. The verifiability, the authenticity of the documents and the returns that are filed by the second respondent. It is important.
Have you exhibited the forms you have yourself?
Yes, my Lord, and I was...
Which are different from the ones IBC has...
we have.
Yes.
I was coming to that, and we have been accused of not pleading these matters. In the affidavit of Billy Atudo, because scrutiny arises out of our pleadings and our affidavits, the affidavit of Billy Atudo addresses this question thoroughly. It is in volume 5 all the way to, and the annexures from volume 5 to volume 14, where he addresses even the Muranga forms, the Garissa forms we have produced, all 100 of them. We have produced the ones that have been availed by IBC, from the ones we got from the IBC portal, and the ones that our observers produced. In the application, we simply made it easier by putting them together side by side so that it is easier for reference. But they are all part of the affidavit, and the annexures already filed in court in support of the petition. I have said from volume 5 all the way to volume 14. They are referred to also for reference to where in the affidavits they are found. It is paragraph 35 to the end, and also from paragraphs 3, we talk about the forms and the discrepancies in the forms. My Lord, on the question, on the issue of the complementary method of identifying voters, the 1.6 million voters, the law is very clear. The Elections General Amendment Regulations 2017, at Regulation 31, my Lord, and I can do no better than to read what the law already provides and compare it with what the IBC gave, the instructions they gave to their presiding officers. Regulation 69 was amended at subregulation E that in case the electronic voter identification device fails to identify a voter, the presiding officer shall invite the agents and candidates in the station to witness that the voter cannot be identified using the device. The presiding officer shall complete verification Form 32A in the presence of the agents and candidates and identify the voter using the printer register. My Lord, Form 32A is one of the returns that ought to have been filed and produced before this court. None has been availed, not one. And it is through Form 32A that we can verify these voters that are alleged could not be identified through the electronic voter identification device. Again, just to show that that is what is expected, in our application we had referred earlier to the guide that was given by the second respondent to its presiding officers. At page 130, what should be done where a voter cannot be identified biometrically but can be identified alphanumerically, it states what is to be done. In the event the voter's details are not retrieved biometrically in the first instance, clerk should make a maximum of 3 attempts. It goes on to say what should be done. In case the details are not retrieved in the third attempt, Clerk 1 will proceed to undertake an alphanumeric search using the voter's ID, passport number, or name, or scanning of the barcode. In case of supervisor validation, the PO completes the KIMS supervisor validation form, see the form below, and invites the party candidates' agents to sign the forms as witnesses. These KIMS supervisor validation forms are part of the returns that are supposed to be produced by the second respondent to verify those who were not identified biometrically. They have not produced any of those forms. They go hand in hand with Form 32A. My Lords, then part of the documents that are supposed to be submitted at the end, together by the presiding officers to the returning officers, at page 142, the second respondent makes it very clear what their presiding officers should do. And they say, together, packaging and delivery of election materials, together with other materials, the presiding officer should deliver to the returning officer the ballot box, the original result declaration Form 34A, any used or spoiled results from Form 34A in a tamper-proof envelope, the register of voters, polling station diary, KIMS kit and all its accessories, failed Forms 32A, failed Forms 32, statement of rejected ballots, Form 41, and KIMS supervisor validation forms. These are returns that are supposed to be delivered by the presiding officer to the returning officers. They are the same forms that are supposed to be used by the returning officers to verify those who are not identified biometrically and to carry out the verification process at the National Tallying Center. So when we talk about verification, how do we verify what the second respondent is talking about when they have not availed the materials or the returns that they should have produced?
You should wind up.
May I have a minute to wind up, my lord? My lord, finally, the respondents talk about time and that we do not have time to do this or to do the scrutiny that is called for. Sampling is a widely accepted method of studying large numbers of subjects. This is what the court did in August. This is what the court did in 2013, and which is why we're asking for a sampling. It is not impossible to do, and the court should not be scared away by this data overload that the second respondents are trying to project before the court. I think I will leave it to that unless the court, sorry, my senior Mr. Ndubi will do the last remarks if that is okay with.
Yes. It's only one last point related to the submission of Mr. Mahat, not Mr. Muhati, that after I explained the various forms of verifying a voter, it appears, or I seem to understand him to mean, that after failing to get a voter in the KIMS kit, there would be another complementary mechanism of having that voter vote using a separate register. That indeed goes to the heart of our application because it will suggest that there are two registers. And if there are two registers, if I understand him correctly, then there is an issue that must be verified in the scrutiny. Thank you.
No, that's not what he said. What he said is that when you put your fingers on the KIMS kit and your particulars don't pop up, they search and search, and then they ask you to put even, is it the 10 fingers?
Yes.
And eventually, if that comes up on the KIMS kit, you've been identified by the KIMS kit. When you fail all those, they go to the manual register that they have, and then you fill the form, is it 32A?
That is the point, my lord.
Yes.
That the KIMS register must have every voter. That is the complete register. Yes. If there is a manual register that you are identified from when you are not in the KIMS register, then that means that there are two separate registers. That's the point.
But I thought the manual register is the same one printed from the electronic register.
You see, the KIMS kit ought to show, in addition that it will show how many times you have attempted to be seen, and you can't be seen at all in that register, in the KIMS register. It means you do not exist, you can't exist in a separate register. That second register would be an illegal register.
All right. Of my understanding, Mr. Ndubi.
Yes, my lord.
And I thought I saw that. My understanding is that the electronic register, the hard copies that go to the polling stations are printed from the electronic register. Yes. Correct me if I'm wrong. So that we are not talking about two registers here, we are talking about one register. Only one, hard copy,
The point
and
of
the other one is in soft copy.
The point I'm making, my lord, is that if there is an electronic register, which is the KIMS register, you may fail to be identified by your fingerprints.
Yes.
But there will be the alphanumeric way of getting you. That using of the ID number, the key in the ID number, you will be noticed that you exist there. Yeah. If you do not, but you exist in a hard copy register, then that hard copy register is not the copy of the KIMS register. Very well.
My Lord, may I just clarify that particular point that he's seeking to make? My Lord, the position is that whenever the biometric voter register is the register, whenever a voter is not identified biometrically or through the biometric voter register, then any other identification method is a complementary identification method. And that is what was even said in the Court of Appeal case that dealt with the issue. The register, the main register, is the biometric voter register. Any other method of identifying a voter is a complementary method, and which is why the Forms 32A then become very critical. Again, it is for the same reason the KIMS kit actually records the number of attempts that are made before a voter is identified in any other manner.
Okay. My Lord, there's a lot of confusion. I was in the case.
No. We can't go on back and forth.
Yes. I thought to clarify that point because they're causing a lot of confusion unnecessarily. Yeah. Because I was in the two cases, in the High Court, in the Court of Appeal, and before this court. And what happened was that the court said the complementary mechanism for identifying voters is Regulation 69, Subregulation E. And the words are very clear. In case the electronic voter identification device fails to identify the voter, the presiding officer shall. So we all agreed that was a mechanism. And as my Lord quoted very correctly, when that system that Mr. Mahat has explained comes to its end, there is a Form 32A to be filled. And that was the consent then recorded in the Court of Appeal, together with the memo that my friend explained, and which is the subject of a very long document, which is part of our documents here, explaining in the fresh presidential election how that was implemented in compliance with that regulation. There is a specific regulation, and that is what it says.
After consultation, we have decided that we will hear arguments on two more applications. That is the application to strike out a party, and the application, which party is sought to be struck out?
Fourth respondent.
The fourth respondent is which party? NASA. Yes, and the application to join Jubilee in which petition?
Petition number 3.
Yes. We will adjourn and come back after 1 hour and hear oral submissions on those applications. The oral submissions on those applications will be limited to 15 minutes each. So synchronize your arguments in your mind and come so that we are able to save time. Is that okay? Fine. So we adjourn and come back after 1 hour.